He has been consistently calling the complainant from jail. It was 130 times or something like that. Yeah.
The only way for me to be able to ensure that the complaining witness is not called is to put him in segregation. I don't understand why you guys aren't filing additional charges anyways. Do you understand?
No.
Don't contact the complaining witness. Don't use anyone else to contact the complaining witness. Don't use anyone else's number to contact the complaining witness.
This case honestly left me speechless. Imagine someone calling their ex more than 300 times while sitting in jail. Even while locked up, he still found ways to repeatedly contact someone on the outside, which shows a complete lack of boundaries and judgment. You can tell the judge is already frustrated the moment the hearing begins. The prosecutor walks in prepared, laying out a detailed call log that shows just how constant and excessive the calls were. It's not a small misunderstanding, it's a clear pattern that's hard to ignore. Meanwhile, the defense tries to lean on a technical argument, as if fine print can erase the reality of non-stop calls day after day. That approach doesn't really address the core issue, and the judge seems to see right through it. This is one of those moments where you can feel the court's patience wearing thin. The whole hearing gives off the sense that the judge is just about done dealing with excuses and delays. When behavior is this repeated and this obvious, explanations only go so far. Let me know in the comments if you've ever dealt with someone who simply refuses to accept consequences or take responsibility. Now let's dive in and see how this plays out.
Mr. Avella here.
Hey.
We're here on Mr. Wiggins. I'll let him.
Something else happened?
So, Judge,
No.
he has been consistently calling the complainant from the VPL from jail. I believe at last check on Friday, it was since March 26th, it was 130 times or something like that. Yeah. So,
Back in.
Well, he's in
He's
custody.
already-
He's in custody.
Go. Ag seg. Goes in ag seg.
Judge,
So privilege is revoked.
I'm gonna have. Can we get Ramona to make a record for
Sure.
that? Okay.
so,
I'm up.
Judge,
Yeah.
Ramona wants to know for on the record.
Oh.
Yeah.
We are going on the record. If you want to talk, please go outside. Okay, so guys, for the record, please announce yourselves. Stay.
action of the equity statement.
Anna Edie, EADY for Mr. Wiggins.
Nathaniel Meunier spelled M-U-N-I-E-R, also for the defense.
So hold on, before you get into anything, stay. You wanted to bring something to the court's attention.
Yes, Judge. So we had received a call that Mr. Wiggins was in violation of a protective order that was in this VPO, and that he was reaching out to the complainant witness in this case. We have checked the jail calls. Those jail calls show that since March 24th, which is 24 hours after the October VPO, since just March 24th, we have 293 calls made to the complainant's phone number. Just yesterday, we had at least 28 calls to that number.
So in one day, you're saying he made how many calls?
So yesterday, he attempted 28 calls to the complainant's phone.
There is absolutely no way the prosecutor just casually dropped. Yeah, he called her 28 times yesterday. Like that wasn't completely unhinged. That's not persistence anymore, that's full-blown obsession with a capital O. If my phone lit up that many times from the same jail caller ID, I'd seriously consider throwing the entire phone into another dimension. And the wildest part is the judge is actually trying to handle this the right way, but the defendant is making it nearly impossible. You can tell he's probably using other inmates' pins to get around restrictions, which just makes everything worse. The amount of effort it takes to pull that off from inside a jail cell is honestly impressive in the worst possible way. What really blows my mind is how someone with that much time and energy chooses to use it solely to harass a person who clearly wants nothing to do with them. This is exactly the type of guy who later acts shocked when the court stops being patient and starts treating him like an actual threat. At this point, it's not about misunderstandings or mixed signals, it's about repeated, deliberate behavior. So yeah, now the real question is how the judge decides to clean up this mess. Let's see what happens next.
So, Judge, I'm going to preface this conversation with, Miss Edie texted me about 10 minutes ago, so I came up on short notice on this. But my understanding is that there's no longer protective order in effect, because it's been long enough. The protective order.
There's an order for him not to have any contact with her.
Are those part of his bond conditions?
Yes.
My client's not on bond.
Well, this not supposed to have any contact with her whatsoever.
I understand, Judge, but the way that this court and other courts in the county have structured those conditions have been bond conditions, which my client is not on a bond. He is in custody. He has not broken
I
the
have
law.
ordered him, even though he's in custody, not to call her.
I understand, Judge. Assuming that he had violated some form of court order that is not a bond condition, I believe the appropriate remedy would be contempt, which would be a separate criminal proceeding. At the same time, for Miss Edie talking to me today, it sounds like that the court was going to order ag-seg in the jail, so the formal
The only
term...
way that we can revoke phone privileges on someone is ag-seg.
Yes, Judge. My issue with that is it's a hammer when a scalpel is needed. So while I understand that the district attorney's office has alleged that my client is called a victim in this case, there's no protective order in place. The bond conditions are not in effect because he's not on bond, thus no crime has taken place. And third to that, Judge, if he's to move to ag-seg, he would not be able to make any phone calls, not just to the victim, but anyone, including counsel, which while we are here on a misdemeanor, he is in custody on a felony and relatively serious felonies, and not being able...
Okay, I understand your plight,
Yes, Judge.
but there are other remedies for you to be able to communicate. Letters, in person, but the only way for me to be able to ensure that the complaining witness is not called is to put him in segregation. That's the only way.
Judge, the problem is nobody would be able to be called, including our office as well as his felony attorneys. Letters through the jail are notoriously slow. A letter to my mother, who lives in the same city, takes 4 days. Add in the jail, you're taking over
And
a
I'm
week.
willing to put him on the docket one time a week so you guys can have contact.
Which the problem is, Judge, we would no longer be able to have any form of private contact, and that would only take care of the misdemeanor and not the felony. And not to be impolite, Judge, him having conversations with us are saying, hey, what's going on with the felony? And any jail visits that take place in ag-seg are actually recorded. They're notified by counsel going through the door that those calls are being recorded.
I don't have any other option to not
Well,
prevent
Judge,
phone calls.
this would violate my client's 5th, 6th, 8th, and 14th, off the top of my head, constitutional rights. Right, self-incrimination, because every conversation is going to be monitored going in and out of the jail because they're going to be recorded via jail visits. He will no longer be able to have private visitation inside the courthouse.
Okay, so now the defense rolls out the classic, well, technically, argument, which is always a bold move when the judge already looks one eyebrow twitch away from losing it. He's basically saying that since his client isn't technically on bond, the no-contact rule shouldn't apply. And I'm sorry, but come on. You don't get to hide behind technicalities after calling someone 300 times. I don't care if you're on bond, off bond, or calling from Jupiter. The intent here is painfully obvious. It's the legal version of a kid waving their hand an inch from your face saying, I'm not touching you. Everyone knows exactly what you're doing, and pretending otherwise just makes it worse. You can almost feel the judge sitting there thinking, I cannot believe this is the hill you chose to die on. We've all dealt with people like this, the ones who break the spirit of the rule and then act shocked when they still get called out. Whether it's sports, school, or real life, technically has never fooled anyone with authority. And in a courtroom, that kind of argument doesn't make you look clever, it makes you look desperate.
You can pull him out. You can have private visitation in the rooms there.
Not about me, Judge. It's about felony court. It's a serious issue, but that's the.
Why are you worried about felony court?
Because that's why he's in, Judge. Then
It's also in because of ours. Our bonds are $60,000.
I understand, Judge, but the reason that this is taking as long as it is, and it's been taken as serious as it is because he's in custody on a felony. And this court making him to where he cannot participate fully with counsel is...
There are other means for you guys to participate, but I've ordered you not to have contact with her. You've called her now over 300 times. I don't understand why you guys aren't filing additional charges anyways.
Sorry, Judge, I missed the last statement.
The only way that I can prevent him from making 300 phone calls is to put him in another wing.
I was going to talk with the DA, and obviously, if my client's making these calls, and that's an if, he's dialing a single number. The jail's numbers can be easily blocked. I've done it on my cell phone numerous times when I've changed cell phones. Over the weekend, last weekend, I had 15 jail calls from one client. And as annoying as that is, it's very easy to block it on your cell phone. And I assume the victim could do the same. I have not heard anything from the state.
Tell the victim what to do, Nathan. I'm not gonna say, can you please block your number so we can't call you?
The least restrictive means, Judge. strict scrutiny dealing with
I have
constitutional rights.
no other way to prevent him from making phone calls. I have acquiesced to you guys before, and I have admonished him before. Please don't. We put you in seg last time. You were there a month. You came here begging and pleading, I'm not gonna do it, I'm not gonna do it. And now we have 300 phone calls. So I don't know what else to do. But now I'm back in accent.
I'm going to sprinkle the word allegedly to the phone calls because it's the kind of thing where records would exist that have not been provided to the defense by the state.
Do you have the records?
Well, I mean, I have them. I just have to get I have to do the form, so I get them up a little bit. Yeah.
Okay, so let's set up a formal hearing because I don't want. You're right. I don't want to give you state the benefit of the doubt without him actually or Anna actually seeing it and seeing that the phone calls were actually made. So let's set up for a formal hearing. How soon can you get him the evidence?
I mean, it could be tomorrow. It'll be a few days.
And if we could keep him in normal population so that we could visit him, as does his felony counsel and make
Mr. Wiggins, I'm going to have you sign an affidavit from today promising me you're not going to reach out to the complaining witness in this case by any means. If you do, I can have a contempt hearing, and every single time it's punishable by up to 6 months in jail and a $500 fine per the advice of your lawyer. Because he thinks this is the correct avenue instead of ag-seg. Do you understand?
No.
Don't contact the complaining witness. Don't use anyone else to contact the complaining witness. Don't use anyone else's number to contact the complaining witness.
I'm going to rephrase what he just said. That means calls going through third parties. So if you call mom and have mom call her, that's against the rules. If you call mom and have mom forward the call, that's against the rules. I said real.
And now it all comes down to a signed promise. The judge is basically giving him that final put it in writing moment before he can legally drop the hammer if this guy calls again. And I'm not gonna lie, watching him swear he won't make contact after already blowing past 300 calls is almost comedic. Like, my guy, you ignored every rule up to this point, but sure, this piece of paper is gonna be the one that changes everything. You can tell Judge Fire is trying to be methodical and patient, doing everything by the book so there's zero wiggle room later. But at the same time, you just know his thinking, there's no chance this guy actually sticks to this. This isn't about confusion anymore, it's about impulse control, and nothing we've seen so far suggests improvement there. The promise feels less like a solution and more like a setup for the inevitable consequences. So what do you think? Does this end here, or is this just the calm before another violation? Let's see how it wraps up.
This is the affidavit that you're going to sign promising me you're not going to contact her or the complaining witness in any of my misdemeanor cases. Do you understand? But just get it as soon as you can, get it to them. Have a hearing on Monday to see whether he's actually making the phone calls that we ordered him not to.
This is you swearing that you will not make these calls.
And let it be clear that it truly have no least restrictive means than to deny his ability to make phone calls to the complaining witness. There really is no less restrictive means.
Judge, my understanding is that the jail can prevent Mr. Wiggins' SPIN number from calling.
In the last time, he used someone else's SPIN number to make the phone call.
That was last.
So,
Yeah.
well, we'll see this time. I don't know. Okay, all right.
Just for we tell the record, Mr. Wiggins, I want you to make this aware that this is the court having you swear, which is legally binding, that you will not be making any calls. And if you violate this sworn oath, then that is punishable under the law. You understand?
Sure.
Okay. Thank you, Judge.
Thank you.
Thanks, Ed. See you Monday.
I wanted to approach on Mr. Wiggins.
Yeah. Sure.
So, and Louis come out to approach him, and I was in the process of getting the calls and everything, and I was informed that they were able to just block the number in the jail. So, and I wanted to just kind of
But he uses other people's SPIN numbers to make the calls. So even if you...
yes. And so...
Allegedly.
Right. So essentially the reason that I wanted to approach is first of all to let you know that I still haven't gotten the calls. I'm not sure what the ETA on that is.
You said it for Monday, right?
Yes.
Yeah. And I just wanted to let you know, I mean, from the state's perspective, when I talked to Jason, when I talked to, my superiors, when our act was to block the number. And I wanted to, kind of let you know that has happened. Thankfully, in the last however many days, there's been no calls to that number at all from the jail. So I wanted to make you aware of that as well.
Can they block the whole phone number so that no one with any spin number can access it?
I can certainly ask.
I think that would be the option.
I think that would be optimal.
Because, what we have here in the last time is the way that they were doing, what he was doing allegedly was he was using other people's spin numbers or SID numbers or whatever it is to be able to make the phone calls.
And, when I was looking through the records, I didn't see any spin swapping because I ran obviously her number by itself. I didn't see any spin swapping recently. I understand that was an issue before. And we hadn't blocked, I guess I would block her at the number since October or anything like that. So I didn't want to let you know, just because I know that we have that hearing and everything. I wanted to let you know that, from our perspective, our ask was kind of met. So I wanted to, just kind of be a
So you don't want to go through with the hearing? Is that what you're saying?
I think that our concern and what the state's ask was initially was met. So I understand obviously for you.
Before you do that, make sure that they can't use someone else's spin to make a phone call. Because if you can, then I think we're still in the same boat, because that was the problem before. You're going to block him now, but if he can still, do it in another way, yeah. And then just, I guess, let me know between now and then,
And my understanding is that since Monday, no one from the jail has called that number, not just Mr. Wiggins. So there hasn't been any spin swapping since Monday.
Right, but it was never supposed to be.
I understand, Judge.
Yeah, and I more so just wanted to, be candid that was what our ask was initially.
Okay.
So,
Well, just let me know. I mean, ask that question. I think that's the most operative question at the time, and then we'll see what they say.
Okay. Thank you, Judge.
Okay.
That was honestly exhausting to watch, because it really highlights how difficult it is to protect someone even when the offender is already behind bars. Jail phones feel like one of the biggest loopholes in the system, and guys like this know exactly how to exploit them. The defense tried to frame it as a matter of his so-called rights, but at some point the victim's right to peace has to outweigh one man's access to unlimited phone calls. What really blows my mind is how many procedural hoops the judge had to jump through just to stop a single person from harassing someone who clearly wants no contact whatsoever. This wasn't about legality anymore, it was about common sense. And yet the court still had to move slowly just to keep everything airtight. It really makes you wonder whether people like this ever learn anything from these hearings at all. The behavior doesn't scream reflection or accountability, it screams entitlement. Let me know in the comments if you think the judge was too patient here, or if this was the only way to keep it legally clean. Thanks so much for watching. Guys, make sure to like and subscribe, and I'll see you in the next one.